Joint tenancy. Part 1. Implication of MUIS latest fatwa on joint tenancy. This presentation is based on research and books written by Sadali Rasban on the main challenges faced by Muslims in Singapore on estate matter. Joint tenancy upon death of a joint tenant. You will have some understanding what is joint tenancy from the state law. You will also understand in greater details of joint tenancy from MUIS perspective in their latest fatwa. Ultimately, you as Muslim should decide to accept joint tenancy or to agree with MUIS fatwas and reject joint tenancy. Objective. This presentation will help the viewer to understand MUIS latest fatwa on joint tenancy issued in Singapore in 2009. We will discuss about MUIS latest fatwa released to the community. There is no intention to discredit this fatwa, but merely to understand the consequences in the implementation or the rejection of the fatwas by some sector. MUIS latest fatwa. The Fatwa Committees 2007 to 2010 reviewed the initial fatwa on joint tenancy at its 5th meeting on 3rd April 2009. This review was made due to difficulties faced by widows that were raised by Sadali Rasban through his book. It was presented by Head of Mufti Office on 15 July 2009 in a convention, Financial Planning from Muslim Perspective. There are two parts to this fatwa. The first part: if no other arrangement or agreement has been made between the joint owners of a property upon death of one of the joint owners, the surviving joint owner will not have full ownership of the property. This surviving joint owner shall only be entitled to half, 50% of the value of the property. The 50% entitlement arises from his or her position as a joint tenant. This part of the latest fatwa reinforced MUIS' previous fatwas that the deceased shares is 50% and the surviving joint tenant is 50%. MUIS still upholds the opinion of joint tenancy is not Sharia compliant. This is followed by another statement to part 1 of the latest fatwa. The other heirs of the estate of the deceased cannot, however, compel the surviving joint tenant, the widow, to sell the property until such time as it is suitable for the surviving joint tenant to sell it. At the same time, the surviving joint tenant cannot delay the sale of the property without reasonable grounds, as it may encroach on the right of other beneficiaries. This statement is to cushion the immediate enforcement on the widow to sell the house and distribute the share according to Fara'id system. It does not solve the issue on the assurance of a shelter, home for the widow and children, but just to delay the distribution to a later date. The widow also cannot delay in disposing the property without reasonable ground when she becomes more able. The second part of the latest fatwa: if, however, other arrangement or agreement have been made between the joint tenants, either through a hiba al-rukbah conditional gift or a nuzia, a vow, which expressly stated that the property is to be given wholly to the surviving joint tenant in the event of death of one of the joint tenants, then the entire property shall vest in the surviving joint tenant. This is consistent with the present law on joint tenancy in Singapore. This statement seems to ensure that the surviving joint tenants can have the property should one of the joint tenant dies. The joint tenant must sign an Islamic deed like nuzria or hiba or rukbah, stating clearly the intention to give the property to the surviving joint tenants. This is an additional requirement for every Muslim to do so with the cause, just to have a joint tenancy contract to be in harmony with MUIS' previous fatwas. MUIS' latest fatwa implication. Let's analyze the first part of the fatwa. We should analyze these statements in the fatwa. if no other arrangement or agreement. When the joint tenants signed the agreement, they were well advised by the officer or the solicitor on the nature of this contract. They had a clear understanding of the arrangement and agreement between them when they signed the contract. This statement, if no other arrangement or agreement, is a clear indicator that the Fatwa Committee is not well informed on the subject. The surviving joint owner will not have full ownership of the property. This above statement may make past cases become contentious again. It will lead the irresponsible legal heir to press their claims more forcibly with the backing of this latest fatwa statement. New cases from past death will appear. Example, a surviving joint tenant stayed in the property for many years after the death of the other joint tenant and has yet to distribute the property as per MUIS previous fatwa. This situation can lead to new conflict among the legal heirs and the surviving joint tenant. Such time as it is suitable for the surviving joint tenant to sell. This statement is very ambiguous. When is a suitable time should the widow, surviving joint tenant, sell the property and divide the property based on the faraid? Who will decide when to sell the home? Reasonable grounds. What is a reasonable ground? Who will decide what is the reasonable ground? We shall now analyze the second part of the fatwa. Other arrangement or agreement have been made. The Fatwa Committee failed to accept that there is an arrangement and agreement among the joint tenants when they signed the contract. This reaffirmed that MUIS did not recognize the joint tenancy contract, that is, the civil law arrangement and agreement made by the joint tenant. They insist that the arrangement and agreement must be made in the Sharia way, that is, to use the hiba al-rukba or nuzriya to achieve the same objective. The question which you ask is, what is so un-Islamic and not Sharia compliant about a civil arrangement and agreement? In today's buying transaction, we use civil arrangement and agreement of buying and selling. Such arrangement and agreement is well accepted by Muslims today. So why can't we accept the civil arrangement and agreement of transferring a joint tenant property to surviving joint tenant? Hiba al-Rukba. Sekali Raspan, the author of Hiba al-Rukba and Joint Tenancy in Sharia law, has done hundreds of Hiba al-Rukba contract deeds on joint tenancy to fatwarize the transfer in accordance with MUIS initial fatwa since 2004. Hiba al-Rukba is a contract of survivorship. That is, the survivor of the contract will take over the ownership of the property. We will give a better understanding of this subject in the next presentation. Fatwarize is a process of harmonizing the civil law and fatwa issued by MUIS. The writer believes that the joint tenancy principle is in alignment with Hiba al-Rukba principle. Thus, joint tenancy can be embraced by Muslims as an innovative tool acceptable under Sharia law. This will be explained in the other PowerPoint presentation. Nuzriya, a means of wealth transfer that is only practiced by some Muslims in Singapore. No other Muslim countries and Muslim scholars in the region recognize Nuzriya. It is a controversial tool. We will elaborate this controversy mechanism in the next presentation. This mechanism has been treated like a will by the Singapore High Court. Conclusion 1. The latest fatwa by MUIS on joint tenancy does not solve the challenge faced by Muslims. It defers the problem to a later date. It will possibly cause more problems and hardship to Muslims. 2. Magnify the problems. Because of the deferment to sell the property, more legal heirs will be involved when there is a death among the first layer of legal heirs before the home is distributed based on the faraid. This increases the number of legal heirs. This will certainly cause more problems and hardship to all parties. 3. Create new problems. The latest fatwa endorses action of responsible legal heirs to demand their rights when such time as it is suitable for the surviving joint tenant to sell it. The surviving joint tenant who had not complied with the initial fatwa is now at risk of being pressured to comply and distribute the share of the property based on faraid. 4. The fatwa definition is shallow as it focuses on shares of the legal heirs based on faraid rather than the objective of Sharia, giving rise to injustice. The fatwa ignores the responsibilities attached to the shares as demanded in the Quran. This creates a perception that the Sharia law is unjust. 5. The Fatwa Committee fails to understand the joint tenancy contract is between the joint tenants. The fatwas issued focuses on benefits for the legal heirs of the joint tenant based on the faraid system, not the joint tenant. The fatwa should focus on justice for the joint tenant. This will certainly raise question of credibility for the Fatwa Committee in understanding the subject. 6. Reinforcing the use of Nurzia on joint tenancy to Islamize the transfer with MUIS fatwa with no solid evidence that it can be supported in Sharia law is damaging to the principle of Islamic jurisprudence. 7. MUIS fatwa is untenable. More and more Muslims will find MUIS fatwa untenable. They will not dispose a home based on the fatwa, thus acquiring property that is not theirs. This simply means that more Muslims will end up taking firestone from hell. 8. There is no recommended solution to manage the joint tenancy property that is to be sold and distributed based on MUIS fatwa on a later date when the surviving joint tenant is ready to sell the home. 9. The fatwa has been commercialized for personal gain. Opportunists have commercialized the fatwa for their personal monetary gain, not solving the challenge. 10. MUIS fatwa is only an opinion, not the Sharia. The fatwa created interest in the media. A commercial company took advantage of the media to write articles to inform Muslims that MUIS fatwa is the Sharia, when in fact it is just an opinion. This is erroneous information given to the public. 11. Against public policy, Masalah Musalla, public interest. It goes against the public policy of the government of Singapore to provide a home for the family. The fatwa gave the impression that the public policy is not in accordance with Sharia law. Thus, we should reject the use of joint tenancy when in fact it is in accordance with the concept of Masalah Musalla, public interest, one of the sources of Sharia law. 12. It will be difficult for Muslims in Singapore to own a home, as when there is a death, the house needs to be disposed based on faraid, as stated in the fatwa. In most cases, the house has to be sold. 13. Widows or the children will always live in fear and insecurity as the deceased legal heir can claim their rights to the home at any time. 14. MUIS rejected survivorship principle in joint tenancy but accepted this survivorship principle in Hibah al-Rukbah. MUIS fatwa contradict each other. The initial fatwa reject the principle of survivorship. The latest fatwa accepted the principle of survivorship. A very confused fatwa. Recommendation. Muslims should realize that the latest fatwa on joint tenancy does not solve the problems created by the previous fatwa. It creates more challenges to Muslims in Singapore. Muslims should also realize that such fatwas are not binding to the courts and Muslims in general. It is unfortunate that the fatwas have been exploited for monetary gain, not to uphold the Sharia. MUIS should revise their fatwa and accept joint tenancy. MUIS should consider embrace joint tenancy as a Sharia compliant means of wealth transfer. If they can accept CPF domination as a hibah gift, why can they accept joint tenancy? MUIS should also stop promoting Nuzria as a special means of wealth transfer. The Nuzria cannot be defended in a court of law and contain many gawra uncertainties in the contract. Please tell your friends and relatives about this presentation and proceed to the joint tenancy part 1 on Nuzria presentation.